Hello, I'm Coleen Trimble, your co-host for today's presentation, along with my colleague, Don Lennard with DeMarche. Don and I are both senior consultants, and we also want to welcome Craig Kovarik. Craig is an ERISA attorney with Husch Blackwell here in Kansas City. We also want to welcome future individuals that view the recording because we know that everyone's schedule is busy and this is an important topic, so we appreciate you taking the time to view this, and we hope to give you some key insights to take away, and or perhaps this might serve as a confirmation for some of the decisions you've already made, and or offer some pros and cons about ways that you might need to change some things going forward. So just as a brief recap of what we'll be doing this morning, Craig is going to start by talking about some considerations of ways in which to mitigate potential litigation. Don is going to discuss some case studies, specifically that we've experienced here at DeMarche, and then I'm going to go over an investment governance checklist. So with that, again, we will welcome everybody. We thank you for attending, and I welcome Craig to begin.
Thank you very much, Coleen, and thank you, Don. I want to thank you all for inviting me to present today. It's an honor, and this is a very important topic and one I think a lot about for our clients, and I know DeMarche does as well. So one of the things I want to talk about is some common themes for these types of litigation. And I know everybody wants me to provide a silver bullet, and there aren't any silver bullets here. So we're going to talk about some case studies in a bit. And I think these common themes are going to blend in nicely with the case studies that Coleen and Don are going to be talking about. For some quick history here, I think an early case was Tussey versus ABB, and this goes back to 2006, which is one of the earliest fee litigation cases, and that case went on for 12 years. It was an Eighth Circuit case in the Missouri area, out of St. Louis, and went up and down, up and down. And so 12 years of litigation over fees. Ultimately, they settled for $55 million after 12 years. And of course, the attorneys got 40% of that cut, or reportedly close to $20 million. So you can see the significance of the dollars. And none of our clients and none of DeMarche's clients want to be in litigation for 12 miserable years. Looking back to 2006, I was listening to the TV coming in, getting ready to come into work today. And by the way, that's when America's Got Talent just started. So 15 years of America's Got Talent is when the first significant fee litigation came out. So for starters, so these are some of my common themes. These cases have largely focused on jumbo plans, and everybody can have a different definition of jumbo plan. And recently, we've seen a case. I think there was one filed last week that was as low as $300 million in assets. But most of these plans, at least lately, have been really large plans of $1 billion plus. But I think if a plan has $500,000 or more, just by being large in that size, you're a potential target for at least on the radar of plaintiffs' firms. The thing that's, from my perspective, to be honest with you, many of the plans that need the most help and probably have the most fiduciary issues are the small plans, because many of the large plans have some sophisticated retirement committees. At least they have the benefit staff to do the right thing, trying to do the right thing. Many of the smaller plans just don't have the resources. But the reality of it is, this is a plaintiff's litigation game, and you need large plans because you need large potential damages in order to make these attractive for plaintiffs, and they're sophisticated litigation. So it's just the nature of the beast. Obviously, the major common theme, there's different theories on all these pleadings, but a lot of them have common themes. And of course, the number one is that plans are not using their size and are paying excessive record keeping fees. We all know that this started in the 401k space, and just recently, in the last 2 or 3 years, has expanded some to the 403b space. It started primarily in the university setting with some very large plans for all major universities that we've all heard of, the Dukes and Harvards and such. But of course, it's also extended into the healthcare system space as well. And 403b plans have a unique history, and there's significant differences. In many ways, 403b plans operate and kind of feel like a 401k plan, but prior to 2009, they were significantly different, and their fee structures and the way they were set up and the vendor system was different. And so this is another area that we're seeing a trend. Another common pleading is and again, and Coleen and Don can speak to this far better than I can, but we've seen a trend towards indexing, and one of the issues is that from a pure performance perspective, in some scenarios, index funds have outperformed active management. And again, the investment experts can talk about that and have explanations and all that, but some of the complaints is you've offered poor performing active mutual funds. And look, all you had to do is offer these low cost index funds and our participants would have outperformed. Of course, there's a counter argument to that, and we can talk about it, but that's one of the complaints. And so I'll talk briefly in a moment about what I believe is a potential for helping to minimize exposure is by adding index funds. Another common theme, again, is just having poor funds, failure to monitor your investment options, your core options, failure to monitor your qualified default investment, your default investments. Another theme is having too many proprietary funds. As an example, if I chose to have Fidelity as my record keeper, one of the claims is that you offer too many Fidelity funds to the detriment of performance. Tied to that is also the failure to use the lowest share class. Back in 2015, there was a Supreme Court case, Trimble versus Edison, involving the issue in that case really was a statute of limitations issue. Edison International added retail funds to their fund lineup in 1999, I believe. And so then there was a lawsuit. And the issue that was before the Supreme Court was whether the plaintiffs had standing to sue or whether the statute of limitations had run. And the idea was, hey, we added these retail funds many, many years ago. You should have brought your claim within the statute of limitations period. And so the Trimble versus Edison was important is because it laid the foundation that said, nope, fiduciaries, you have an ongoing duty to monitor your investment funds. So that statute of limitations is constantly running. And so that's a very important case and a common theme. What we're emphasizing here is the need to continually, every single year and as long as you have this plan, to have this ongoing, you have an ongoing fiduciary obligation to monitor your funds. Another common theme is active. This has to do with your target date funds, your QDIA, qualified default investment funds. And again, it ties into, it's all tied together, but one of the arguments is you're offering active target date funds to when you could have offered a passively managed target date, a set of funds that outperform the active management. Now, Coleen reminded me, and she's absolutely right, that there's never truly any passively target date funds, because within the target date funds, you've got asset allocation. So, and within an index, you also have you have the index team that are deciding who's in the index and who's not. So, nothing's truly passive. But again, that's a common theme that you see in some of this litigation. The last point here is again, there's some very important cases that have been litigated, and I don't want to suggest to you that these cases aren't that these cases never go to court. But as everyone knows, litigation is very, very expensive. It shocks me. I'm not a litigator. I'm a substantive lawyer. But when I see bills for litigation, it's ridiculous how expensive this is. And so employers and insurers and fiduciaries, rightfully so, they don't want to litigate this because it's so costly that a lot of these cases have been settled. The cases have settled for big millions and millions of dollars in relation to the total size of the plan, maybe not huge, but again, millions of dollars, multi-millions of dollars. I'll be very brief here. I thought this might be interesting for those that don't litigate and hopefully aren't in litigation every day. But this is sort of the 4 key phases to an ERISA litigation matter. And again, this isn't critical, but I thought this is sort of litigation 101, even for me. But phase 1 is you get a lawsuit and you go through this procedural. Phase 1 goes through procedural steps. There's a motion to dismiss. The defendants try to narrow the claims. They make sure that they have proper standing, that the parties have proper standing to sue, that you're in the right court, that the claims can't be dismissed on procedural grounds. Okay, so that's the goal. Is you would like to get, as a defendant, you'd like to get out of the litigation at an early stage on a motion to dismiss. Okay. And if you don't survive motion to dismiss, then you go to the next phase, a motion for summary judgment. And then essentially phase 2 is you make your brief to the court saying, look, even if we assume all the facts are true, the plaintiffs don't have a case, and as a matter of law, this case needs to be removed. Okay, dismissed as a matter of law, even if we assume all the facts being true. If you fail at the summary judgment phase, again, from a defense perspective, you go to phase 3, and that's where you get into discovery, and that's where the litigation teams get into all the discovery, and ERISA has unique discovery rules. And then, of course, the 4th phase is bench trial. I can say that phase 3 is very expensive. Obviously, phase 4 is expensive, but phase 3 is very expensive. And many times you'll see these cases being settled after phase 1 or phase 2. Okay, so I'd like to turn and talk about some potential strategies to avoid litigation. Again, as I mentioned earlier, these are not silver bullets. Coleen and Don may disagree with some of these. Certainly other lawyers will disagree. The good thing about being a lawyer is there's 2 sides, and I can argue both sides of this. But these are themes and thoughts that I think in my practice that I think are helpful. And again, I think that Coleen and Don are going to expand on these as we talk about this. So, of course, we all know the way that we're judged as ERISA fiduciaries is through our procedural prudence. Okay. Again, this is not going to prevent us from potentially getting a lawsuit, but by following procedural prudence, we're satisfying our requirements under the law, and it may help us get out of the lawsuit early by being able to demonstrate to the plaintiffs that we have done everything we're supposed to do. And so this is a good, strong defense. Okay, procedural prudence means that we have a formal committee, right? We know the committee knows who they are. They are routinely meeting, they're having meetings, they're diligent in their efforts, and they're carrying out their fiduciary responsibilities with respect to the investments, okay? Maintaining minutes is critical, okay? The other thing is about minutes is a real art, in my opinion. You absolutely want to demonstrate and have strong minutes to show that you're exercising all your fiduciary responsibilities and doing everything. But at the same time, those minutes need to be carefully drafted and reviewed before they're finalized, because those minutes can be subject to discovery by plaintiffs' lawyers and, of course, participants as well. So again, it's critical to take the time and be thoughtful and make sure that your minutes are carefully drafted, thoroughly drafted, fully reflect everything that the committee did, deliberated, talked about, while at the same time being smart and strategic about what's disclosed. Okay. Procedural prudence, of course, absolutely includes benchmarking. Benchmarking your service providers. Very difficult. We are so busy at our jobs, and life goes so fast that before you know it, you haven't benchmarked your plan for 7 years, 8 years, 9 years, 10 years. And of course, you're satisfied with your third-party record keeper, namely because no one's griping about it, right? You don't hear gripes from your employees, but benchmarking is critical. Okay, and there's different forms of benchmarking, and Coleen and Don can talk about that. There's full RFPs and there's RFIs, and then there's just routine benchmarking of gathering data. That's absolutely critical. There's obviously been a huge change in the way that third-party fiduciaries fees have come down, and so benchmarking is even more important today. Okay. This next thing I think is very important, and again, for jumbo plans, large plans, I think this is almost universal. It is critical to have a third-party expert or an advisor. Okay. You can have the most sophisticated retirement committee, and there are folks that absolutely are on your committee that have a passion about investing, and we all know those folks, right? But unless they're doing it every single day as part of their job, it's difficult to make the argument. It certainly cuts against you if you got into litigation, that those folks are expert advisors. And so, to me, if I was a fiduciary, what would I do? I would absolutely look to outside experts, third-party independent experts, to help me make a decision. Okay, so I think that's very important. And of course, again, I think for the jumbo plans, large plans, that's going to be the case. This next concept is something that maybe many on this video will understand. Under ERISA, there's two types of, when you hire an advisor, there's two types of advisors you can have. One is a co-fiduciary relationship, and that's under Section 321 of ERISA. And a co-fiduciary think of it as your advisor comes to the committee, makes recommendations, and then of course you need the consensus, and ultimately the discretionary authority is for the committee. The committee is going to listen to the co-fiduciary, the investment advisor, and collectively they're going to come together, but ultimately the committee is going to sign off. Another way to potentially minimize fiduciary responsibility from a plan sponsor's perspective is to hire an investment manager in a 338 capacity. Okay, and so that's when a plan sponsor or committee would say, okay, they would interview and do their due diligence and hire a third-party investment manager and give that 338 investment manager the full discretionary authority to make investment decisions. Okay, so a good example there would simply be the investment advisor believes that a particular mutual fund is underperforming for whatever reason. That a 338 investment manager would have the discretionary authority to pull the strings and change the investment advisor without having to go back and get the approval of the retirement committee. Now, I want to emphasize, if there's a lawsuit, the retirement committee is certainly going to be brought into the lawsuit and will be named as a defendant. Okay, but by outsourcing to a 338 investment advisor, I believe that the retirement committee fiduciary would have a better opportunity to get out of the litigation early. Okay, now the 338 investment manager still has to be monitored. Okay, you have to monitor the fees, you have to do all that sort of stuff, and periodically benchmarked and so forth. And of course, the 338 investment manager is going to only agree to do that, to agree to serve as investment manager with a very detailed investment policy statement. So there are still fiduciary responsibilities that a retirement committee has, but this is one way that I think, frankly, many clients should focus on their business and outsource that. But we haven't seen, there's not a huge trend toward that. Another thing is just passive versus active funds. We have seen in some scenarios, some cases, some have made the argument that I'll have an all passive index. I'm going to focus on fees alone. I'll offer an index only core lineup and if that, and use that as a mechanism and get rid of all active funds. There are arguments in favor of that. I think, however, if you're offering a true lineup as a fiduciary, it seems to me that there are certain investment scenarios where active may outperform passive, and there's a case for active management in a core lineup. Okay, so I think having a blend between passive and active is the right way. But certainly, as some of the litigation early cases saying that, hey, we're not offering enough index funds. So I think it's important to have index funds across all your core lineup. Another possibility would be to include a brokerage window. And so, again, this is fairly common in jumbo plans. And some employers are apprehensive about this because they have a fear that, one, folks are going to day trade. And I think those days have passed. We certainly saw, we were all frequent traders back in the late 2000s. And we saw how that ended. But I think others have this fear that they need to protect their participants from themselves with these brokerage windows. I would argue purely from a legal perspective, adding a brokerage window potentially provides you with the opportunity to argue. And there's a Seventh Circuit case involving John Deere, which the court agreed with this, is that, look, if you don't like the core investment lineup, okay, you think the funds are poorly, they're poor choices, they're high fees, you have this brokerage window at a pretty nominal cost, and the universe is yours. So that's another opportunity from a litigation strategy to potentially minimize your exposure. Some other ideas would be fiduciary outsourcing. Again, this is similar to the 338 investment manager. The market is changing, and maybe not in the jumbo space, but certainly in the smaller markets, where the idea is you've read about pooled plans, sort of the multiple employer type plans, where you're really outsourcing your plan administrative responsibilities to a third party by really signing on to a third party resource and simply making contributions and letting them deal with the plan. Another thing we're going to talk about a bit, I think, in the case studies, but is as plan fiduciaries, this gets back to our record keeping fees, is we really need to evaluate how we're paying for those fees and whether we should be paying for those fees on a per head basis, per participant basis, or an asset-based fee. And we need to make sure, if we have an asset-based fee, which the Department of Labor has blessed, that we as fiduciaries monitor that fee to make sure that the fees generated through those asset-based arrangements don't become excessive. Okay. This next bullet is one that I think is a really good idea. And we frankly have not seen it adopted broadly. And this is to simply say, hey, we're going to take this off the table. We're going to pay our plan. We're going to negotiate the lowest cost we can with our third-party vendors, and we're not going to use plan assets to pay these fees. We're going to pay them outside the plan. Okay, I think it's pretty common for, certainly not uncommon, for plan expenses related to investment advisors, for example, and certainly the audit fees. Both investment advisor and audit fees are clearly plan expenses that could be paid out of plan assets, but it's not uncommon for employer plan sponsors to pay those outside the plan. And so there you don't have the opportunity for plaintiffs to say that you're using, misusing plan assets or paying excessive fees because participants aren't paying for them. Well, if plans could do the same thing with record keeping fees, again, you would be taking that off the table and and potentially diffusing any argument that you had excessive fees in terms of record keeping fees. Of course, you still have to monitor your investment funds, but I think that's a good idea. All money is green, right? And so if employers would think that way, they can factor that in the terms of the level of their match or other retirement contribution. They can take into account their paying those plan expenses outside the plan. Also, if you could do that in the form of you could sell that as a real employee benefit to your employees. These last two bullets, this is all great news. This is all pretty maybe common stuff that lots of folks on this listening to this review or understand. But one of the things that I've struggled with is, it's today, it's 2020. What can we do backwards? What can we do? We have a good, we can change this, we can improve going forward. What can we do backwards? And unfortunately, I don't think there's a ton of what we can do looking backwards, okay? But one possibility would be to go back and review your prior plan minutes, okay? Now, we can never go back and redo minutes, and we can't go back in time and recreate minutes, okay? That's not something we're talking about. But we're saying go back and review your prior plan minutes and make sure they accurately reflect what the committee actually did, okay? Did we poorly draft our minutes, okay? And if we poorly drafted our minutes, there's not any problem, in my view, of updating those minutes to reflect what we did. Again, that I'm not talking about recreating history. I'm talking about making sure that our prior plan minutes are reflective of the full committee's review. The other thing I think that can be done is to conduct a proactive fiduciary audit. And that means have somebody come in and say, okay, this is what we're doing, and let's look at what your plan, what's your plan lineup, what are your service agreement contracts, what are your vendor relationships, and have somebody independently review your plan and give you kind of a fiduciary review from an independent source, and I think that would be another valuable source for employers. So with that, I'm going to turn it over to Don, who I think is going to talk about some case studies.
Thank you, Craig. Again, my name is Don Lennard. I'm a senior consultant at DeMarche Associates. I want to echo what Coleen and Craig have already expressed. We very much appreciate the time you're taking to review these materials. It's been our pleasure, and we have enjoyed putting them together for you. What I'm going to discuss, as Coleen and Craig alluded to, are some actual cases where we've worked on a client behalf, typically on a project basis to start. In most cases, these projects lead to us becoming the consultant for the client, but you'll see that clearly our value proposition here and our value add is the independence that we offer in terms of our perspective, in terms of how the plans are being managed. The first case we'll talk about is a large public health system. This public health system has about 7,000 employees, a little over $600 million in retirement assets. And from the beginning, what we identified very quickly, they had multiple proprietary funds, underperforming mutual funds, and they had multiple record keepers. So we knew that at the onset there were going to be some things for us to really sink our teeth into. So some issues that we identified, one thing we identified was choice overload. When you began as a new employee and you were eligible for plan enrollment, you were presented with sleeves of investment options from 2 different record keepers, and there were over 35 different options for you to invest in. And I would ask that you look at some information we've put together and some white papers that we've done on just choice overload, because that's a real phenomenon and a real problem, and it leads to suboptimal decision making. That's available on our website, and we certainly would like to share that with you as well. We also saw in this case significant revenue sharing. So you'll see a lot of the things that Craig already spoke about that are problematic, and certainly we saw that in this case, where a lot of active funds in the lineup, some performing okay, some maybe not performing as well, but all offering really significant amounts of revenue sharing. This particular client also had annuities in the lineup. It was a health system that had been around for a long time, and maybe at a time and place where annuities were more in vogue. And a lot of those annuities were not performing very well. Some lacked benchmarks. To the next point, this client also did not have an investment policy statement. So that was, an obvious opportunity for us to help in that regard. Something Craig and other counsel have talked to us about before. There's an old expression called full heart, empty head. You can have the best intentions and really want to do the best job as a committee member, but if you don't have the appropriate background to consider elements of the plan that are important and to really conduct your fiduciary duties, you really don't belong on the committee. This client delegated quite a bit of decision making from the board to this investment committee and really didn't realize what that really entailed. So what did we do? Well, on their behalf, we conducted a record keeper RFP, or request for proposal. So we were able to go out to the marketplace, assess the current providers, as well as new potential advisors or record keepers for this particular plan. We did a fund performance assessment. So we looked at the total lineup of all the strategies in the plan. We did a mapping exercise in this case because we had to really combine the best elements of both plans when we identified the record keeper that the client wanted to go forward with. We drafted, working on behalf of the client, an investment policy statement, and then we worked with both the board and the investment committee and our chief compliance officer at DeMarche to provide them with fiduciary training as appropriate. What were the results? Well, again, now the client has a single record keeper. All revenue sharing has been removed. The remaining funds in the lineup now are collective investment trusts or have an institutional share class. We introduced a record keeper flat fee of $50 per plan participant. The average plan participant there was paying slightly over $300 because, again, a lot of that was based on revenue sharing and deployment of active funds. As I alluded to earlier, the IPS was written and approved by the board and adopted. We replaced a couple of investment committee members, as I alluded to earlier. Fiduciary training was provided. We also introduced a tiered system, and Craig spoke of this earlier, where now we have, in this case, each choice in the lineup, whether that be a small cap, mid cap, large cap, emerging market, has both an active and a passive option. That way the plan participant can really express their preference for one or the other in that way. The target date fund was moved to a passive strategy because we think that's the most important part of investing really is asset allocation, and that's what we want the target date fund to do and to get right, and the provider to get right. We reduced the investment options by more than 50% at the end of the day, and really these two last points go together. So choice overload, I would say, is really no longer a big issue. The bottom line in this case, we removed over $2 million in plan costs. Those have been eliminated, and almost entirely those had been borne previously by the plan participants. The fiduciaries, which is very critical, now understand their roles and their responsibilities. They have the IPS, the investment committee has the IPS to provide guidance when things are uncertain. And again, our opinion is that the plan is much more defensible versus potential litigation. The second case also involves a health system, although this is a private health system, just about as large, 6,500 employees, a little bit smaller. The plan had not been around as long, $300 million in retirement assets. This client has worked with DeMarche for a long time on the pension side, and they were starting to become more concerned because of the litigation, some of which Craig alluded to, and the fiduciary-related risk associated with the retirement plan, both for the main hospital and the affiliates of that hospital. Well, in working with us, some issues we identified fairly quickly, the IPS was stale, and by stale, I mean it hadn't been updated for several years. In going through the lineup, there were a number of underperforming funds. They had a mismatch between active and passive strategies. So they did have some passive strategies in the lineup, but there really wasn't any rhyme or reason to how they were being implemented or deployed. There was, like the last case, significant revenue sharing within several of the options. They had a target date fund that not only was active, it was also underperforming and really a laggard versus its peer universe. They also used annuity payments, annuities in this plan, but the payments were based on overall plan fee generation. And what that basically meant was, as long as revenue sharing was high and the record keeper was collecting a lot of revenue, they could keep the annuity payments up. This is a situation we saw in the last case. The funds were lacking appropriate benchmarks. And the last thing, every plan participant, including even target date fund and passive investors, I have an exclamation point there on purpose, were paying a $160 advisory fee separately. So no matter what type of investing you were doing, to have access to this advisor, even if you were just a passive investor or you already in target date fund, your account was being debited, if you will, for $160 every year to pay an advisor. So some actions that we undertook, again, you'll see some common threads here. Record keeping RFP, we did a fund performance assessment of total lineup, the mapping exercise, because as I alluded to earlier, there were 3 record keepers, and we got their IPS really updated to current standards. What were some of the results? Again, going from 3 record keepers to a single record keeper. The record keeper flat fee of $52 per plan participant was implemented. That had averaged $206 prior to that time. Like we did in the prior case, all revenue sharing was removed. The remaining funds were collective investment trusts or institutional share class. We updated the IPS. We drafted that and working with the client, and that was approved by the board. And we introduced a tiered system where each choice, had both an active and a passive option. And the bottom line in this case, over $1.3 million in plan costs have been removed. The advisory fee removed for plan participants, that $160 fee that most of them, I'm sure, had no idea about, that was removed. We made a change to the annuity payout was no longer tied to record keeper fee generation. We reviewed again the roles for fiduciaries and their responsibilities. The IPS now again provides that really important guidance, and we feel very strongly plan much more defensible versus potential litigation. The last case I'll discuss with you today is a long-term client of ours, a Fortune 500 client, with the 401k plan, about 3,500 employees with $450 million in retirement assets. And they were just concerned because they were, following the same headlines that many of us were with the fiduciary risk associated with the 401k plan. They had never had a consultant work on their behalf on that plan, although we'd worked for them for years on their defined benefit plan. And the interesting thing is, when we started working with this client on their K plan, their record keeper had identified themselves in written materials as their consultant. And we quickly pointed out that they certainly couldn't be an independent third-party consultant because they lacked that independence, because they had agency issues, because they wanted those fees associated with some of the funds in the account, and obviously being the record keeper as well. So they were naturally conflicted. So identified a lot of issues here. This was a very, an older plan. The last record keeper search that they had conducted was 18 years prior. So they kept the record keeper around for a long time, but really, and it's one of those relationships where neither really challenged the other. The bills were assessed, the fees were paid, and they moved on. But again, that was something that we thought we could take a look at for them. Again, stale IPS, investment policy statement. Underperforming funds in the lineup, a mismatch between active and passive strategies. We also found a very strange thing where the record keeper was assessing a fee for the fact that they have proprietary funds in the lineup, where you'd think they'd be maybe discounting that. They would actually were assessing an additional fee. It was in the very, very fine print. And I've seen situations here, I'm sure both Craig and Coleen have, where there might be a page or two of footnotes on some of these things. You really have to dig into them and understand what you're being charged and how fees are being assessed, et cetera. There were also a case here where there were sector funds in the lineup, and the client really didn't understand the nature of the funds that were in a lineup until we did the attribution on some of these funds and pointed out that in a couple of cases they were really quasi-energy funds or quasi-technology funds. So I think those were good things to help the client understand. To Craig's earlier point too, in this particular case, 90% of the plan consisted of proprietary funds. So those were funds that were associated strictly with the record keeper. In some cases, the benchmarks were incorrect. Those needed to be addressed and fixed. There was, a fair amount of revenue sharing. The record keeping fees were high. And again, there was a basic understanding, but I would say somewhat limited understanding of the fiduciary responsibilities they have within the organization. The courts are less sympathetic about that because if you don't manage your DB plan particularly well, that's going to eventually be a balance sheet or an income statement issue for you because you're going to have problems with funding that. With DC plans, they're not going to be nearly as understanding, so we really need to up our game and fiduciary responsibilities with this particular client. What were some actions that were undertaken? We thought the first thing we need to do, and the client was really anxious to get this done, was to do fiduciary training for the investment committee. And that was done. We also did an RFI, a little bit different than an RFP. This is a request for information. So we sent it out to a number of potential vendors as well as their existing vendor. And because they like their existing vendor, but some situations needed to be addressed, the existing vendor actually ended up retaining the business, but certainly we'll talk about it in a minute on a different cost structure. As we've done in previous two cases, we've talked to you about fund performance assessment. The total lineup was something that we looked at on their behalf. And to Craig's point too, we researched and we established for them a brokerage window so they could keep some of those sector funds and those really high beta, higher potential risk funds, but keep those in a brokerage window separate from the conventional lineup. We did a mapping exercise for them, and we also updated their investment policy statement. The record keeping fees in terms of results were reduced. They weren't as dramatic as other examples we've talked about. We cut those by a little bit more than half, from $126 to $52 per plan participant. And what's really happening, as Craig alluded to, we are doing these on a flat fee per participant basis, where in the past that was really kind of done in a way that wasn't very transparent and based on revenue sharing and a lot of other considerations. A tiered system was introduced. Each choice has an active and a passive option. Introduced a brokerage window that was added for qualified participants, and removed those sector funds from the conventional lineup. Added some new investment committee members, updated their IPS, changed their active target date fund to a passive target date fund, and identified and addressed by removing them underperforming proprietary funds. Bottom line here, again, more savings flowing to plan participants, amounting to over $700,000. We have an IPS now providing really good guidance. We're confident the plan, more defensible versus potential litigation. And again, we have a situation now where the fiduciaries on the investment committee and the board understand their roles and responsibilities. So I think it's important for me to emphasize that, although a lot of our recommendations end up being, somewhat similar, every engagement that we get into at DeMarche is unique, and sometimes in very material ways, which you've probably picked up along the way. We certainly don't offer any cookie cutter approaches in the way we approach these types of projects. In each of these cases that we discussed with you, in a lot of cases, they start with projects. And Craig alluded to this earlier, just doing a fiduciary update or a checkup is very important. And for an independent party for us to come in there and really assess what's happening with the plans. And it's obviously a great way for us to demonstrate our capabilities. Quick conclusion, I'm reminded of a comment by a board member upon completion and delivery of a project for them about 1.5 years ago. Obviously very appreciative of our work, and they commented that they thought now they'd be able to sleep at night. So I think that's probably the highest type of compliment that we can be paid for this sort of work. So I'm going to now pass this along to my colleague, Coleen Trimble, who's going to talk about the importance of using checklists. Coleen?
Thank you, Craig and Don. Craig did a great job of introducing some of those areas where we've seen some litigation issues. And Don did a great job of highlighting some case studies that actually reflected some of those issues that Craig talked about. And I liked Don's closing in that he described one of the investment committee members' ability to sleep better at night. And, you know, I think if that's one thing we can do for our investment committees, that's certainly one of our top goals. And along that thinking, we had a client once come to me. This particular client was my client, and they really recognized that they needed some DC oversight. So I give them credit for that. First of all, recognizing what you don't have and what you need. And secondly, they realized that they needed some structure in place. So they knew that they needed these pieces like an investment policy, and they knew they needed to be doing performance monitoring and all of those different pieces or components of investment fund oversight. But they felt there were so many pieces, and so what we decided we would do was to put all of the detail together in one document, and it's a best practices investment governance checklist. Now, this ended up being 10 pages long because there's lots of detail here. But the client loves it, and they use it as a living document. So they can accomplish a task, they can check it off, they can keep referring back to it, they can refresh it. So it's really been of help to them. Now, this investment governance checklist was tailored to the client. And this client was a 401k plan. So some of the component pieces might change if it was a 403b or a different kind of a DC plan. But overall, there is much overlap. However, when you think about individual clients, there may be some cases where you would need, as a client, to have this tailored for yourself. And one thing that really comes to mind is your level of resources. So something else we did on this investment, this detailed investment checklist, was we indicated who or what entity would be responsible for doing that particular task. So again, rows and rows of tasks, and that might include the internal staff, it might include an advisor, consultant, it might include an outside counsel or inside counsel or a record keeper administrator. So there were several different entities that could be responsible for these particular tasks. So what I'm going to go through right now is just a quick overview of the 4 main topics that we included in the investment governance checklist. And that was basically investment goals was number 1, investment structure was number 2, investment manager oversight was number 3, and then fees was number 4. And then I've listed some subcomponents to consider. So I'll go through those. But please keep in mind that, again, I'm talking about an investment governance checklist here. We did not cover a checklist that might talk about setting up your plan, right, or your record keeper or compliance, things like that. So those are whole other checklists perhaps that you could create. So the first point here is establishing, you're looking at your plan in terms of its foundation. What are the goals, policies, and objectives, and what are the key points that you need to consider or sub-bullets that would go beneath this? And then, as I said, there's going to be many, many detailed steps and tasks under each one of these. But one of the first things you do is you set up a committee. And dependent upon the size of the plan, you may have 2 committees. You may have an administrative committee and you may have an investment committee. For smaller plans, they may only have 1 committee. dependent upon the plan sponsor's preference. Another thing that is important about the committee consideration is the number of members. You want an uneven number of committee members. We prefer 7 or less. If you get much above 7, there's a lot of discussion, a lot of, and discussion's good, but you also need to come to an agreement at some point too. So we feel that 7 and below is better. Documentation, Craig mentioned this, the issue with minutes is crucial. You want more high level, but documentation is very important through every project that you do. So sometimes it's not even as much about the result. You know, Craig and both Don mentioned about target date funds being active or passive. There are many cases for active target date funds. There are cases for passive. There are cases for blended approaches. But the most important takeaway here is for you to document your process. That's key. Also, in terms of your committees, you obviously need insurance and you want to indemnify those committee members. Don mentioned in his case study about annual fiduciary training. That's really important because as fast as the DOL or ERISA laws change or come into new context with the evolution of DC plans, it's very important to do that on an annual basis. And you not only bring in ERISA attorneys, both inner and or outer, you also could bring in your investment consultant to do some specific training for those committee members that maybe are lacking in particular areas of their fiduciary responsibilities, or bring in your record keeper, and especially bring in your investment managers to talk about investment performance from time to time. And then another key area in this is fiduciary considerations. You know, just in brief, that would involve your protocols and your processes and making sure that even something, quote, as simple as making sure the plan is diversified, that you are following 404C rules. These are some of the types of things that would be outlined in the fiduciary considerations. And then lastly, you of course want to establish an investment policy. And that's where you determine whose responsibility it is to do what, and what are your primary objectives, and what kinds of benchmarking are you going to establish, and when do you fire a manager, when do you hire a manager. And just a side note here, we see that sometimes a watch statement is included in an investment policy, sometimes it's not. Sometimes it's an outside document. There are pros and cons about including a watch list in an IPS. So that's number one. Number two, and again, we're talking about the key primary topics here within this checklist. The next one would be looking at your investment structure and strategy, or your plan menu per se. Don mentioned in his case studies about the tiered structure. DeMarche is a big advocate on providing or recommending a 3-tiered structure. In other words, a tier that you want someone else to make the decisions for you, particularly as it is in a target date strategy. Tier number 2 would be, I want to do it myself. That's your core lineup, and that ideally would involve both active and passive funds. And then thirdly would be the quote expert tier, or a tier where you want to take maybe a little bit more risk, and you may have one sector fund, or you may have a brokerage window, that kind of thing. So it's the third tier is where people have much more experience. And the reason you want to do this in a 3-tiered structure is that you want to match the tiers with the with the participants' attitudes toward investing, so that they can feel more comfortable in making the decisions. And then also, when you're marketing or you're educating, you can also target to those core cohorts in a more efficient manner. And then annually, you want to evaluate your menu, or take a quick look at it. It should be seriously looked at every 3 years or so. And you want to make sure that you've minimized the number of options. Don mentioned the issue of choice overload. So you want to minimize the number, but you want to make sure that the efficacy of those investment options are strong, and that they cover the primary asset classes. And you don't want them to be heavily correlated. So you want them to be act somewhat different in different market cycles, if at all possible. So that means you may want to add something like more of a real estate fund at times, because that's going to act more differently than perhaps a large cap fund. So that's important to look at. Again, there's a whole list of considerations when you look at that menu on an annual basis to make sure that something doesn't need to be changed. We are advocates of target date funds. We think that's a good way to focus in on helping someone easily prepare for retirement. There are pros and cons. We've done a primer for several clients about target date funds that is probably 10 pages long with considerations that you need to look at when you're implementing a target date fund into your lineup. It is not as simple as it sounds. There are many considerations. Quickly, you want to make sure you have institutional vehicles in your plan. You may have some retail funds, but if you have retail funds, make sure that they're not loaded up with revenue share. We prefer institutional funds like an R6 share class fund or a CIT, and even separate accounts if you're a huge mega fund. So look at those vehicles, make sure that they're apropos for an institutional DC plan, which is what we are building toward or want to maintain. Make sure you document all your reviews. Keep on top of trends and best practices. Again, DC plans are evolving. And, even annuities, they're starting to come back and get more attention now. There's still lots of pros and cons about annuities, but I think as the time goes on, we're going to get those to the place where they're going to be more palatable for investment committees. We may not be totally there yet, but I think we're heading a little closer. Consider miscellaneous plan features like auto features. That has been an accepted, auto enrollment now is pretty accepted. Also is auto escalation feature. In other words, you increase the contribution by a certain amount based on, for example, a participant's raise every year. So there are some plan features that are becoming they are becoming standard features, and they are no longer even considered unusual. Lastly, I'm going to throw in the idea of reviewing your company stock. That can be an issue. You need to have ERISA counsel's view on that. That's a DeMarche opinion. Okay, the third major component within our governance checklist is a manager oversight. In other words, hire, fire, and monitor decisions. We have an entire list of the criteria that we look for when we are looking at evaluating a fund or a manager. And that's not only quantitative, but it's also qualitative. This client that came to us and was the impetus for creating this investment governance checklist, they were certainly doing quarterly monitoring, but they were simply looking at performance versus a benchmark. I'm not even sure they were doing peer benchmarking. They were doing a passive benchmark. Okay, that suffices for some quarterly monitoring, but you need to do something much more beyond that. And so you also need to implement a yearly monitoring if you're not covering such things as risk statistics, metrics, and qualitative review of managers such as AUM, whether they're maintaining the same process, whether their investment team is consistent, whether they're providing consistent performance, risk-adjusted returns. So there are many things that if you aren't doing on a quarterly basis, at a minimum, you just need to be looking at performance versus benchmarks. But I will tell you, most institutional DC plans today do a lot more than that on a quarterly basis. They are doing a lot more of the major metric comparisons on a quarterly basis. So also on a yearly basis, you need to look at that QDIA. And often, if the QDIA, as it most often is today, a target date fund, the target date fund, when you chose it, was put into place for a particular reason. That reason, in part, was hopefully, likely, based on participant demographics. Demographics may change. Plans merge. Plans sell off aspects of their plans. They buy more companies. Lots of things change about participant demographics. So that's one thing that really needs to be reviewed for your target date fund. I'm not suggesting you're going to be replacing that annually. I'm just saying give it a cursory review to make sure that the reasons you put the target date fund into place is still in place today. Our last key component of this checklist is fees. Now, again, I'm talking about investment fees here, which is only one component of total plan fees. I'm not talking about the record-keeping fees that Dawn and both Craig mentioned in their comments. But as far as investment fees, again, we want to focus on investment vehicles that are institutional in nature. And again, that infers lower or no revenue share. Revenue share is still fine, but you have to review it. You have to make sure it's very reasonable. And you have to make sure that there is some equitable distribution of that so that your participants, if you do have some revenue sharing built in, that they aren't the only ones paying for the record keeping. So that's something you have to work with your record keeper on. And then, and annually, I'm jumping around here a little bit, but annually, make sure you confirm on an annual basis that you are invested in the lowest cost eligible share class or vehicle. Because investment managers come out with new share classes all the time. They come out with new CITs all the time. And one caveat, it used to be several years ago that CITs had really no rev share. Today, we are seeing CITs with more and more rev share. So you have to be careful about that and don't assume that CITs don't have revenue share. And then obviously benchmark fees. You need to benchmark them against the asset class and against peers and make sure that you do that on an annual basis. And also, that's important to benchmark it specifically with and against their particular asset class and their particular share class. Very important to look at it versus share classes. So that is a summary of the key components. I would invite, if anyone listening to this, want us to put together some sort of an investment governance checklist for them. Again, other clients have found it helpful, and it's sort of a roadmap. And I think Craig mentioned that some of the fiduciary issues may even be appropriate with small clients, and that's a great point, because on the big plans, while they may be a target, they have a lot of these components already in place. So for the smaller plans, I think a checklist like this might really be helpful to take away some of the overwhelm that's involved in trying to determine what is important when I look at the investment oversight for my plan. So that concludes my comments. I'm going to thank Craig and Dawn for both of theirs, and I would like to open it up for some questions. And I know Dawn and I believe have some questions for you, Craig, if you are open to that.
Love to, thanks.
Dawn, I think you had a question.
I do. Thank you, Coleen. My question's really for Craig. Craig, I think we shared our case studies in the 3 cases we identified. We were able to go in and remove considerable costs. A lot of those were record keeper related expenses. So my question was, do record keepers perhaps have an agency problem? What I mean by that is, even though they're really not formally, bound by ERISA, aren't they opening up, their client, the plan sponsor, to potential litigation by not informing them that lower cost record keeper services are available? As I mentioned in one of my cases, the client stayed with the existing record keeper after conducting an RFI, but we found out that yes, there was a plan per head fee option available, but no one had asked for it, and that saved a lot of plan expense on a go forward basis. But we'd incurred a lot of costs prior to that.
Yeah, I think from a purely legal perspective, I'd say no. So what I mean by that is, it ultimately, employers, retirement committees, plan sponsors they have an obligation to ask the record keeper. Okay. I'm a lawyer, and I charge my hourly rate. It's not my duty to tell my clients that, hey, someone else across the street might do this for $50 less an hour than me. Okay. From a fiduciaries committee's perspective, it's not their money, right? This is the plan assets. It belongs to the plan. So would it be nice for our record keepers to be more, record keepers need to be more transparent, right? And so if I'm drafting a contract with my record keeper, maybe as a plan sponsor, a committee, I would ask for those disclosures, right? If there's a fee, a breakdown, a lowering of their fee across their base, their client base, maybe then they would have an obligation. But I don't think they have a fiduciary obligation to tell us. It's frustrating, right? I mean, you build up a relationship with these vendors and you expect that. Now, certainly, I want to be careful when I say that is, whenever you pay a vendor, right, technically that's a prohibited transaction, okay? So, but plans could never operate if they didn't pay their vendors for their expenses. And so there's an exemption, right? And that exemption allows plans to pay their vendors for fair services performed. And there is a disclosure obligation, right? And so our vendors, our record keepers, are supposed to disclose all that stuff back to us. So Don, I totally agree with you, and I'm not arguing with you from the standpoint of, should our record keepers be disclosing that information to us? Yes. Can we draft language around a contract to maybe obligate them to? I think so. We probably don't spend that time to do that, and we don't think about that, but yes. But I don't think it's realistic for us as committees and plan sponsors to expect our record keepers to tell them, have them come forward and say, to offer the lower fees. It's similar for an investment manager, right? You all provide your services and you do it at what you think is the appropriate price that you're willing to provide your services. And it's not your duty to go tell a committee that, your competitor across the street may do it for less. Again, it's easy for me because I'm a lawyer to the committees, right? And so again, we could tell clients that they need to benchmark but need to ask those questions. And it's easy for you all because you serve as fiduciaries to the committees, and so you tell the committees, you're an advocate for those committees, and so you're asking the record keepers. Does that answer your question?
Yes, thank you.
Okay, so I have a question, Craig, and we talked about record keeping fees, and record keeping fees have been under a lot of pressure, and they have gotten so much attention because of these litigation. And so it is clear, I think, that the trend is and has been toward per head participant allocation methodology of these record keeping fees. And I do agree, and I think, and you'll agree, that the DOL, though, still says that basis points or per participant fees are fine. The point is that you need to justify and explain the reasoning why you're going to allocate fees based on one or the other. And I just happened to get through working on an RFI for record keeper, and it became really apparent to me that the industry sometimes drives whether the allocation method is per participant or basis point, because, for example, in the retail industry, the assets per employee are so low and the turnover is so high that if you charge them a per participant fee, the percentage is really exorbitant. Yes. So that's a little side note. But I guess my question to you is, what are your thoughts just about the process that clients need to have in place to justify that allocation methodology that they choose?
It's the same. First of all, for our clients, DeMarche clients, Husch Blackwell clients of any significant size in terms of assets, I am a huge advocate for per head fees. Okay, I've sat through many meetings, and I hear the arguments about what you just advocated about the revenue sharing model, and I understand it. My argument would be employers. Again, I'm advocate for paying expenses. Maybe the employer should do a per head fee, and for those small balances or that starter for the first year or two, subsidize the very small balances, right? Some of these people are putting $500 in a year, and if you charge them $100 for their record keeping fee, that's a big chunk. And my argument would be, well, subsidize those folks, but do it on a per head basis. As far as the process, it's the same, right? First of all, I assure you, no matter how you explain it, right? You can explain the per head fee and people understand a per capita fee, and you explain the revenue model. Put pen to paper, make sure that your committee fully understands the difference. I was studying a case earlier, a very large plan, many thousands of them participants, 700, 800,000 million in assets, and they're still using a revenue model. And I talked to the committee, employee benefits manager, and again, sophisticated person, knows what they're doing, but really had not thought through and didn't fully understand exactly how that revenue sharing is flowing through the plan and who's paying for it. And again, these are very sophisticated people. So, Coleen, to answer your question is, I think, again, it's more of making sure that everybody understands it, documenting the rationale, right, and memorializing that in your minutes, if that's the approach you're going to go with.
Craig, I just want to clarify that.
Yeah, sure.
For example, on when you charge a basis point fee, you may not have any revenue share in there. We're not talking about revenue share. We're just talking about whether you allocate in basis points. So, but your point is still well taken. But I don't want to mix up the idea that we're assuming that any time a plan charges basis points that they have a revenue sharing model, because that's not correct. They could be two different things. So,
very good.
Just want to clarify that. Don, I think you had another question, maybe.
I did, and again, it goes to Craig. Now, Craig, a lot of recent attention has been focused on employee wellness, and that's being, presented oftentimes as a benefit in some cases. But where does that start and stop as it relates to advice given to plan participants related to their 401k plan or their 403b plan? And a follow-up question, do you think the courts will look favorably upon a plan sponsor who at least makes an attempt to provide some semblance of financial wellness? If a group of plan participants were, perhaps to take an adverse action related to the retirement plan, would that maybe be a mitigant, hopefully, for the plan sponsor?
I'd like to answer your second part of your question about courts. We haven't, to my knowledge, I haven't seen any courts get to that level. Again, many of the cases that I've summarized, and you're very familiar with, Don, I know you are. They never get to that point. Would a judge perhaps take that into consideration behind the scenes? Perhaps, yes. I think what you're alluding to is, and again, this goes way back. For years we're fearful of providing investment advice to our participants, right? So again, these are all participant-directed plans, and the DOL made us a little nervous, and so there's a reluctance to be hands-off. I think that we're pretty well beyond that. I think that we know how to communicate and provide financial wellness to our participants, and we know the appropriate disclosures. I think there's a good sense that they know we're not providing investment advice. For lots and lots of participants, again, we all know this too, is the trend is to have some simplicity, put them in our target date funds, and hopefully get them to auto enroll and save, more saving and let it ride. So I don't know whether that would help from a litigation perspective, to be honest with you. I think that I am an advocate of financial wellness. I think it's important beyond just your 401k plan for our employees. I think it's a real valuable benefit. And I think if done right, I personally don't see any heightened or significant additional fiduciary exposure. I wouldn't be, if I were an employer, I wouldn't be afraid of that from a litigation perspective.
Okay, excellent. Thank you.
Thank you.
All right. I think that concludes our presentation. I want to thank Craig Kovarik with Husch Blackwell and my colleague Don Lennard with DeMarche. And we want to thank those of you who tuned in, and please let any of us know of any questions or concerns or thoughts that you might have. You will be able to access this on our website. And I will offer Craig and Don any other closing comments you gentlemen would like to offer.
None for me. Thank you both again. I enjoyed presenting, and thank you for the opportunity.
You bet. Don, anything from you?
None for me. Again, thank you, and thank you to Craig for helping out today.
Great. All right. Thanks all. Take care. Be well.